the decisions we make as a first-tier tribunal are for information for our other colleagues, but they're not actually binding. And the binding authorities begin to come as we've been appealed and as a corpus of real knowledge has grown up, either through High Court and Court of Appeal cases or actually within the upper tribunal. The upper tribunal marks our homework very carefully, and I think sometimes rather unfairly, but that's what they're there for. They don't actually have to sit and deal with some of the logistical elements that we cope with. We were criticised recently because in closed session we had only taken handwritten notes and had not had an audio transcript that the upper tribunal could then look at. And we said, well, hang on a minute, it just depends what facilities we get in the various locations we're sitting in. But that didn't seem to cut too much ice with them. We have the capacity to sit as a two-member tribunal with the agreement of the parties, and certainly I've used that on 3 occasions where a lay member has been unable at the last moment to sit. If we can get agreement, then it's possible to sit with 2. And unusually, and it's been like this way from the start, we're not aiming at unanimous decisions. We can have majority decisions, and in fact 2 lay members can outvote the legally qualified judge. It makes it very difficult to write the decision when that happens, but it's one of the tests that goes with the area. How can you express your dissent without overriding the majority view? And on those occasions actually where it's happened, the judicial view has often been upheld as the appeal goes forward. But it's actually very useful to all parties to know that, because you can then analyse, if you've got a split decision, where the pressure points in any appeal may be.